Now, when US forces target and kill a US citizen overseas, someone alleged to have been involved in terrorist plots, is that an illegal assassination or is it a legally sanctioned act of self-defense? Last September, the US citizen Anwar al-Awlaki was killed in Yemen by a US drone attack. He was alleged to be a leading planner and recruiter for al-Qaeda, and he was said to have planned the failed attack by the so-called underwear bomber Umar Farouk Abdulmutallab in December 2009. Well, now the US Attorney General Eric Holder has set out in some detail in a public speech exactly why the US government believes that it is legally justified in targeting people like al-Awlaki, even if they are US citizens.
It is an unfortunate but undeniable fact that some of the threats that we face come from a small number of United States citizens who have decided to commit violent attacks against their own country from abroad, based on generations-old legal principles and Supreme Court decisions handed down during World War II, as well as during this current conflict. It's clear that United States citizenship alone does not make such individuals immune from being targeted.
Well, the key assertion in the Attorney General's speech was that since the attacks of 9/11, the US has been a nation at war, and that therefore the laws of war apply in cases such as that of Anwar al-Awlaki. I've been discussing that approach with Professor Mary Ellen O'Connell, Professor of Law at Notre Dame University, and the former White House and Justice Department lawyer David Rifkin. Mary Ellen O'Connell first. Does she accept that in law the administration does have the power to declare the nation to be at war?
The United States is in war in Afghanistan. That is the only place where the United States today is legally under the international legal definition of armed conflict. That is the only place that we're in war and the only place that the United States is entitled to use military force.
Even if it has reason to believe there are enemies in other locations?
Exactly. Against your enemies, there are a variety of things that you can do. What the United States did before 2001 was to pursue them through law enforcement techniques. That's what it's still doing with many countries around the world. What it cannot do is decide that there is a right to take preemptive military force against an individual or a small group in an area where the United States is not engaged in armed conflict hostilities.
David Rifkin, do you accept the Attorney General's argument that even US citizens can legally be targeted and killed if there is reason to suppose that they are plotting harm to other US citizens?
Not only I accept that, and it's not General Holder's view, that is a very standard proposition, well established in both laws of war and American constitutional law, that your citizenship is irrelevant. If you're an enemy combatant, you can be targeted with deadly force 24/7 on the battlefield and off the battlefield in a zone of active hostilities, or frankly, if you're on vacation.
Does that mean then that a declaration of war, a unilateral declaration of war even, supersedes all constitutional rights and guarantees that US citizens are protected by?
With respect, they don't supersede them. The norms, the content of the norms is different. The easiest example, the one I don't think my colleague would have any problems with, is American Civil War. In American Civil War, the American government used deadly force and killed dozens of thousands of American citizens without any judicial imprimatur. And nobody seemed to have a problem with that because you don't get judicial imprimatur prior to plunging, pardon my French, a bayonet in somebody's belly. And the use of drones is absolutely no different as a matter of legal architecture.
Without going back to the legality or otherwise of what happened during the American Civil War, Mary Ellen O'Connell, if you are right and that geographic location is a key to deciding the legality or otherwise of attacks of this kind, do you not accept that if the enemy is not itself a state, does not itself have a specific geographic location, then that law really can't be said to apply?
Robin, it's not the geographic location that's relevant. It's what's going on in that geographic location. Are there armed conflict hostilities going on? The United States and the United Kingdom went to war in Afghanistan after the United States was attacked on 9/11. So carrying out self-defense for the year or so until Kabul fell was lawful under the UN Charter. What they can't do is drop 500-pound bombs and fire Hellfire missiles at persons who are wanted for criminal wrongdoing. That's what the U.S. is doing in Yemen. Yemen.
David Rifkin, I just want to move you on to one other point, if I may, because some people listening to you may be asking themselves, if you are right that a declaration of war enables attacks such as that in Yemen last September on Anwar al-Awlaki to be deemed legitimate and legal, then does that not risk implying that any declaration by any president, simply the words, "we are now at war," entitles him to do things, to kill people whom otherwise he would not be entitled to kill?
Does anybody really doubt that we're still at war with al-Qaeda in various places, that they're trying to carry attacks against us? They're training personnel, they're buying weapons, they're making explosives? Am I crazy? Is that not the world we live in versus a science fiction world? We're only in war in Afghanistan?
That's what you're saying, Mary Ellen O'Connell, isn't it?
That's exactly what I'm saying. And David forgets that the United States is not the only country that has a problem with al-Qaeda. In London, in Madrid, in Bali, Indonesia, so many other places, they are cooperating and using law enforcement efforts. None of these other countries have declared a war on al-Qaeda. And remember, President Obama himself said on the campaign trail, this is a lawless, mistaken policy, and the U.S. has to get back to acting consistently with the rule of law. And frankly, after 10 years of killing, approaching almost 3,000 people, the number of persons that the United States has killed with drones outside of armed conflict areas, we have very little to show in terms of having a long-lasting positive impact on suppressing terrorism generally.
Very briefly, first of all, I'm glad to report, and I'm not being sarcastic, that President Obama has grown in office. That while indeed he said this foolishness during the campaign, once he's got into the White House and seen the real facts, he's embraced the notion that this is real war. Point number one. Point number two, as a matter of international law, how other countries choose to respond to an armed conflict does not in any way oblige us to adopt a similar strategy. So the fact that, in my opinion, Spain had a valid casus belli against al-Qaeda and they chose not to treat it as such is absolutely, it's a policy decision. If we had more time, I'll tell you candidly what I think about the merits of a decision, but policy merits of a decision have nothing to do with the laws of war. Under the laws of war, if a country is facing a belligerent that's using military force on a scale sufficient to give rise to armed conflict, we are fully within our legal rights.
I'm very sorry, David, but that is an incorrect statement of the law. Under Article 51 of the UN Charter, for a country to use significant military force of the kind the U.S. has been using with drones, there must be a significant armed attack, and then the country acting in self-defense must only take action on the territory of a state that is responsible for the attack.
Law professor Mary Ellen O'Connell, together with the former White House lawyer David Rifkin.